Recording has started.
Okay, I have 7:03 now.
Okay, so I'll just call to order the special remote meeting for the Sunshine Ordinance Task Force on Monday, June 13th, 2022 at 7 p.m. Cheryl, if you want to go ahead and read the preamble and the meeting decorum.
Let me first read video conference bit.ly code. That's https://bit.ly/3mymta9. Password is Sunshine. Public comment call-in number 415-655-0001. Meeting ID 2491-222-9183 ##. Press *3 to enter the speaker line. Remote access to information and participation. In accordance with Governor Newsom's Executive Order N3320, declaring a state of emergency regarding the COVID-19 outbreak, and Mayor London N. Breed's proclamation declaring a local emergency, issued on February 25th, 2020, including the guidance for gatherings issued by the San Francisco Department of Public Health officer, aggressive directives were issued to reduce the spread of COVID-19. On March 17, 2020, the Board of Supervisors authorized their board and committee meetings to convene remotely via Microsoft Teams and will allow remote public comment via teleconference. Members of the public may participate by phone or may submit their comments by email to cheryl.leger@sfgov.org. All comments received will be made a part of the official record. Sunshine Ordinance Task Force agendas and their associated documents are available at sfbos.org/sunshine. I will repeat the public comment call-in number, 415-655-0001. The meeting ID 2491-222-9183 ##. Press *3 to enter the speaker line. As the COVID-19 disease progresses, please visit the Sunshine Ordinance Task Force website regularly to be updated on the current situation as it affects the legislative process. Meeting decorum. Chair Yankee, do you want to read that?
You can go ahead.
All right. Meeting decorum. Any member of the Sunshine Ordinance Task Force may call for decorum due to disorderly conduct of meeting participants. Persons who engage in threatening and or menacing behavior may be asked to leave. Shall I read item number 1?
Yes, please.
Item number 1, call to order, roll call, and agenda changes. Shall I take the roll?
Yes, please.
Member Wolf?
Present.
Member Wolf present. Member Hill?
Present.
Member Hill present. Member Neighbors? Member Neighbors present. Member Highland? Member Highland not present. Member Stein?
Present.
Member Stein present. Member Padmanabhan?
Present.
Member Padmanabhan present. Member LaHood? Member LaHood not present. Member Schmidt? Did I hear Member Schmidt?
Present.
Okay, great. Member Schmidt present. Vice Chair Wong? Not present. Chair Yankee?
Present.
Chair Yankee present. 1, 2, 3, 4, 5, 6, 7. We have a quorum.
Okay, great. And any agenda changes, Cheryl?
I haven't been made aware of any.
Okay, I'm not aware
I
of any.
posted this. I have not been made aware of any.
Okay, great. So if you want to go ahead and read item 2.
Item number 2, hearing determination of an authorized representative of the custodian of the public records and or the successor custodian of public records for redistricting task force members pursuant to Administrative Code 6721 and the development of a process to hear complaints filed against members of the redistricting task force.
Okay, thank you, Cheryl. So, members, the reason I wanted to put this item on the special agenda here is that we have, I think, 8 complaints that are outstanding against redistricting task force members. All of them deal with a request for public records. I think most of them came in, and the complaints at least were filed were in April and in May. So the issue that we have now is while, the redistricting task force was likely, a group and meeting and that they were all city officials during the initial request for records. Since that time, they've concluded their work and they're potentially no longer city officials because the task force, the redistricting task force, once the map and final report are done, then it disbands, right? So there'll be a series of hearings that we'll have to have for each of these files, and we need to determine who's part of the the city can help members of the public and can show up for these complaints to represent or to be the ones to have the potential access to the records. So there's a series of things we can look to in both the ordinance and some of the attachments, such as there's a specific ordinance made to create the redistricting task force, and that should be attached. We can also look to the charter that briefly describes the redistricting task force. But I think the focus needs to be that if we were to we could find a violation if certain things happened in the past with redistricting task force members. But the question is, if we issue an order or need to go and seek further enforcement action, who are we going to order and who are we going to seek enforcement action or request enforcement action against? So maybe with that, maybe I can let DCA Reese kind of brief us a little bit on some of his discussions that he may have had with DCA Wolf. I know that they met and may have some thoughts.
Yes, hi, good evening. Yeah, I'll share, I think the two authorities that that I look to are the ordinance, specifically 67.21, and that speaks to the custodian of records. And I mean, quite simply, custodian of records is someone who is in custody of a record, of a public record. And so, I think it, frankly, is that simple. I mean, I found similar examples in other state codes, again, where it's, if you're in custody of a record, you are therefore the custodian of records. That it's not necessarily, I mean, in some specific circumstances, it might be kind of a term of art, but otherwise, it really is, more the plain language. And so that is in 67.21 in paragraph A, it speaks of every person having custody of any public record, is essentially accountable under the ordinance. The other authority is one that we actually discussed at length in the last general meeting, which is the City of San Jose case, City of San Jose versus Superior Court, well, depending which kind of appeal you read. But that, as we discussed at the last meeting, that case really does stand for that a public record in an employee or official's personal email or personal device still remains a public record. And the case also includes language about basically being a local agency's obligation to ask employees or officials to search their personal emails or personal devices, as long as that request for them to search is reasonably calculated to discover what would be a public record that's in their, again, personal email or personal device. And so, yeah, I guess we'll start with that for just those two authorities, again, just on kind of plain language of custodian of public record, and then again, public records can reside in personal emails or devices.
Okay, and the other thing, I think we need to have a discussion on. I don't think there's probably much dispute that they were, that each task force member at the time that the requests were made were the custodians of records. but maybe you could speak to how does the Sunshine Ordinance impact people who are no longer city officials? Like what should happen to their records? If I'm sure in other instances, right, people leave, city departments, they leave elective office. And there's certain parts of the ordinance that speak to that, right? They talk about, I think if you looked at 6729.1, there's a section about records surviving transition of officials, but that doesn't seem to apply here. So I guess, where would these records reside now if that they're no longer city officials? Or does the ordinance still have authority over them, even though they're former officials?
Yeah. So again, 6721, talks about, a person who is in custody of a public record. And so, and then again, I'd say that San Jose court decision, again, leaves open that, basically, the decision speaks about basically not taking things out of public records realm because, they might be in someone's personal possession. And there is language that in that court decision that would suggest that also applies to former employees, former officials, where again, if it's, if the record itself is a public record, then, it remains so, even if it's in their personal possession, or even if their status as employee or official has changed. If it's a public record and they have it, then it remains a public record that that should be searched for. Yeah, sorry, I forgot my second thought.
Well, I see Member Wolf has his hand up, so maybe pass over to him.
Thank you. So I think the first question we have to ask, which is the question we always ask in these cases, is when were the complaints filed? Were they filed during the course of when that official was serving? And we always hold that the complaint, that we adjudicate the complaint from the point of time that the complaint was filed. So if they were a public official at the time of the filing of the complaint, then that's when it's valid. It doesn't matter when it shows up on our desk, because the complaint is based upon an alleged violation at the time that they were serving. I'm wondering, David, if you have a response to that.
Well, I guess, as I explained, even if it's, I don't know that the complaint needs to be contemporaneous with their service if they have public records. I think what I'll caution is that, I don't know, maybe a more difficult question is whether, city departments have, retention requirements. And since, those are, we set those locally, that is not something that the San Jose, decision spoke to, whether those, kind of follow someone, after their employment or after, their position as an official. But again, the San Jose decision, whether it was requested while they were an employee, an official, or afterwards, if they have those records, if the task force, deems public records, then those ought to be available to a public records request.
Just a quick follow-up based upon the Smith versus San Jose. Once they terminate their work is terminated after they're done, and they're no longer a public official, then who's to say that, they should be retaining anything? I mean, did anybody give them instructions? Do they have a set of bylaws, or were given guidance by the city attorney for such things? And I'll stop there.
Okay. I mean, I was going to offer, there is, share with the task, so my office does have a publicly available memo that's about the redistricting task force. It's their function and role. I do not believe it speaks to that point.
All right, I see member Neighbors and then member Hill. So member Neighbors,
Thank you. And this is something that's been kind of bothering me. I know I worked a little bit when we put the first statewide redistricting commission together, and worked with supporting one of the members that was appointed. And one of the things about the statewide redistricting commission is that you know, if you're on that commission, your term doesn't expire until someone else is appointed in your seat. So like you can go to Wikipedia and you'll see everybody's got a 10-year term. You know, they're appointed at the beginning and then they leave when the next round of folks come in to serve on the commission. And one of the reasons I think that we did this was for this very reason. Because it's, well, partially it's a much longer process at the state level. It's hard to imagine longer, but yeah, a much longer process. But also the culpability and the responsibility and accountability for those commissioners to the people. And so is there somewhere in besides Smith versus San Jose, I don't know very much about that, I'm not a lawyer. I'm just a sociologist. But I'm looking at the actual ordinance itself. I mean, and this probably is kind of in line with remember Will's question. I mean, were they given do they all have a specific date where that date is you are no longer a commissioner on this task force? And was it spelled out in writing somewhere in the materials, like in the ordinance or elsewhere? I mean, is it possible? I mean, I don't think you can make an argument that they're still serving now because of, ways that we designate who is a public official, like in San Francisco. If you're a commissioner, you have access to health insurance. Do they still have access to health insurance? Probably not, right? But are there ways that, is it just that it's unstated, or is there some other piece of it in the ordinance itself? Because if you're thinking even larger than the complaints we have coming down the line, this might be something we want to signal a flag to folks in terms of updating the ordinance to ensure that the next round of commissioners are accountable for a longer period of time. So that's one of those questions that's like, yeah, sorry.
member Neighbors, if you don't mind, I'll jump in because I'd point you to pay attachment P5. And it's the last sentence on that, and this is part of the ordinance that was passed. And it doesn't have a specific date, but it says members of the task force shall serve until the task force completes its duties in connection with the 2020 decennial census as set forth in Charter Section 13.110D. So presumably they've completed that.
They completed
their duties in connection with it. So
maybe. I don't know. Are their duties still to be accountable for things that they, maybe this is still one of their duties, right? Is to make clear the public records or to provide the public records upon request. This could still be a duty of a commissioner, Maybe.
Yeah. Member Hill and then member Stein.
I heard someone say earlier that, sorry, thank you, Chair Yankee. I heard someone say earlier, and I apologize, I didn't see who said it. I think of it, Mr. Riaz, about he said, if it's a public record and they have it. And so, to me, that begs the question of, number one, and I may be asking the obvious question, just ask it out in public first. Are the members of the redistricting task force emails private emails, or are the emails that are maintained by the city and county of San Francisco?
I remember Hill, I can tell you that they did have sfgov.org emails. I don't know to what extent, obviously we don't know because we don't have the merits of the complaints in front of us, whether they did some or all of their business using other personal email addresses. But they certainly did have access to SFGov email addresses.
I guess thank you for that. The follow up, my just quick follow up is that would we be relying on potential records that aren't already in possession by the clerk of the redistricting task force or some other electronic or otherwise storage and maintenance of any of those records? I guess the question is do we need to be concerned about the fact that like the city and county of San Francisco may not be in possession of records that might be called into question? Because I believe that it might simplify this if what we're searching is already available to the city and county of San Francisco.
I'd kind of point, we had a case a few months, maybe a year ago now at this point, that dealt with 6729-7, and it's about correspondence and records that shall be maintained. And 6729-7 says that the mayor and all department heads shall maintain and preserve in a professional and business-like manner all documents and correspondence, including but not limited to letters, emails, drafts, memorandums, invoices, and it goes on, right? And so, I think we held in that case that, even if an employee left, it's up to the department head ultimately to make sure that there's a records retention schedule and that the procedures are being followed to retain those records, even if an individual leaves. The question in this particular case is, okay, so what would be the relevant department head, or is it the mayor that's the body that oversees or is the authority over the redistricting task force, right? Whose responsibility would it be to retain those emails, to your point, that might be in an sfgov.org email account? And that's, I think, part of the problem that we're facing is there's not, if we looked at something like the library commission, right, we could say, okay, there's a library that would have to do that, or there's a planning commission, there's a planning department that might have to do that. But what's the still existing department that corresponds to that and would be responsible for that?
Mike, and I appreciate that because it looks like that we have three choices: the mayor, the board of supervisors, and or the election commission, who are the three sort of the bodies that were that name the folks on the redistricting task force. But I guess my question is could the clerk of the redistricting task force successfully complete these records requests, or am I barking up the wrong tree here?
If you could see in the attachment to this, I tried to see if the clerk of the board of supervisors, the clerk's office, right, because they're the ones.
I did see that.
And they, did not want to have that, or did not, accept responsibility for that task. Now, that doesn't mean that we can find something that we find that they are responsible, but they certainly aren't volunteering for that.
Right. Okay. All right. Thank you very much.
I see Member Wolf, but let's go to Member Stein first, then we'll go back to Member Wolf.
Yeah, hi. I mean, I think it's to me, it's a very compelling case that these are public records because of the manner in which they were produced, whether or not people are still officials. So to me, the real question is, where are the actual records? Who provided them with documentation and briefings? Who's storing any information afterwards? Who's administering their meetings? And it seems like in this case, it could be with the director of elections, it could be with the clerk of the BOS or the board of supervisors, maybe the mayor. But I think we have to pursue all three and try in terms of trying to get the records that we could get, because these are the people who are nominating the people who are on the committee as well as the individuals. And then we'll find out, was there a records retention policy, or did relevant records disappear because this was kind of a temporary committee that then got disbanded? And if that's the case, that records weren't kept or stored, then I think that's something that we should address maybe in our annual report or maybe in a note to the supervisors that this is important, documentation of an important committee and that there needs to be some kind of record retention policy for it.
Okay, I see Member Wolf.
Okay, I think we're getting a little ahead of ourselves because we have to start with the governing law. So the governing law begins with the charter. And in Charter Section 13.110D, in the middle, it says, if it is determined that the districts are in compliance with all legal requirements, including the requirement that they be equal in population, the current districts as drawn will be valid for the next decade. If it is determined that any of the districts are not in compliance, the Board of Supervisors by ordinance shall convene and fund a 9-member elections task force. 3 members shall be appointed by the Board of Supervisors, 3 members shall be appointed by the mayor, and 3 members shall be appointed by the Director of Elections, unless an elections commission is created, in which case the appointments designated to the Director of Elections shall be made by the Elections Commission. Period. The task force shall be appointed by January 8th, 2002, and following the publication of each decennial federal census thereafter, shall be appointed within 60 days after the issuance of a report by the Director of Elections to the Board of Supervisors that the districts are not in compliance pursuant to the subsection. Members of the task force previously appointed by the Director of Elections shall serve on the task force until the Elections Commission, if established, appoints 3 members to the task force, whereupon the terms of the members appointed by the Director of Elections shall expire. So I interpret this to mean that this is under the kind of the direction of the Board of Supervisors, and that the secretary of the task force shall be the clerk of the Board of Supervisors. So it seems to be within that umbrella of the legislative branch. And so I think if there's any onus, the onus would be on the Board of Supervisors to maintain the records. And I'll stop there.
Member Hill, I see your hand up.
Yeah, just a quick follow-up. Is there a precedent? Thank you for that. Yeah, I think that it seems pretty clear, but is there a precedence for, let's say, because we're talking about the Board of Supervisors now, when there is an elected official who is not reelected, and someone makes a public records request for a copy of emails that are sent to a person who is not a member of the Board of Supervisors anymore, who completes that request currently today? Do we have any precedents for that or history of that?
Maybe DCA Reese, is that something you might be able to advise on? Or maybe even Victor or Cheryl, if you know, by being as part of the clerk's office?
Yeah, I don't know of a precedent. Your question, and again, I'd go back to whoever's got custody, of it. You find that custodian, they gives you that record. But it's other than not knowing a precedent, it's who maintains, typically like departments have, IT departments that, also look over the email servers. And so, it usually, lives with, a department, for an employee or official, simply, with whatever department is providing them the administrative support and the, and with it, the IT.
But there isn't anyone here who has any experience with like an elected official who is no longer a member of the Board of Supervisors and a records request coming in for a copy of their communications.
6729-1.
Right. So yeah, remember Wolf pointed out that there's a section that says that they must survive the transition of officials. And so I guess the question would be, that they're surviving the transition. Obviously, there's a section that says when it's an elected official, they need to, pass it along. I guess the question is pass along to whom though, right? Let's say someone wants, to Member Hill's point, a Prop G calendar from a supervisor that served 2 years ago and is no longer in office, right? Where would those Prop G calendars be? Would it be with the new supervisor? Would it be with the clerk's office?
It depends upon how each of those departments set up their retention. If the records are supposed to be retained by the clerk's office and maintained, archived, curated, what have you, then that's where you would look. I don't know what the rules say with regards to the Board of Supervisors. I don't know about any other commissions or what have you. I don't know about commission members that get that run out their terms, whether they have to submit any documents that they have, that kind of thing. If they have its SFGov email address, usually that's supposed to be archived or backed up, but we've heard many times that departments don't do that. I'm not sure how all that technologically works now. So,
Chair Yankee, this is Victor Young.
Hi, Victor.
It may be a good opportunity to take a little bit of public comment. We may have members of the public who have some information to provide according to some of the indicators.
Sure. I don't see any more hands up at this point among members. So why don't we go ahead and take some public comment and see if anyone else has some thoughts here.
Okay, we have 2 members of the public with us today. I'm just going to go ahead and unmute them one at a time, and they can provide their public comment. Cheryl, are you ready?
Yeah, 3 minutes. Do we have public commenters? Hello?
Can you hear me now?
Hello, caller, you've been unmuted. You may begin your comment there.
Can you hear me okay?
Yes, we can.
Great, David Bilpel. So I had a number of thoughts. Let me run through them quickly. Perhaps you'll have more than one opportunity for public comment. So I want to be clear that on this item, you're not discussing the merits of the complaints. It's just on this question of how do you reach records to the extent that there's a records request related to someone who's no longer serving in office. It's specific to redistricting, but it has broader implications in my view. Among the issues to consider, I think, are whether the person is actually still serving or not, and if they are not, is it a reasonable time period related to them having left office or service. For example, I served on the redistricting task force 10 years ago. Does that mean that someone could file a request and ask for any records that I have related to that work 10 years ago? I would suggest perhaps not, that it's not reasonably close enough. Similarly with, Bob Planthold and the various bodies that he served on, he of course would not be available anymore. So, how does one's change in status, whether it's being alive or not, or still serving or not, affect the analysis of how you reach the records? Conversely, someone who served and left office last week, presumably is still around unless they're on vacation in Africa. And if they still have access to their records, perhaps that is still close enough in time to their service, and it wouldn't be a huge pain for them to do a diligent search, depending on the nature of the records request. Moving on to the retention periods. Again, if you are requesting records that are only required to be kept for 2 or 3 years, asking for them 5 years later, the answer would likely be those records don't exist. Or if those records do still exist, then you're lucky. but it in part goes to the question of the appropriate record retention period and schedule as approved by the department through the process in Chapter 8 of the admin code. I think the best solution all the way around, as I've advocated before, is for everybody serving to be issued an SF-Gov or appropriate city department email address, and for all of their email related to city work, whether they're an employee or an officer, to be routed through that email address, and the department that their function is associated with to have custody of that email, both during their time in office or as an employee, or following their time, again, subject to the record retention periods. I talked about my experience on the task force. I can come back to that if that's useful.
Time is up.
Okay, can I just finish in,
Go ahead
in 10 seconds? Just to finish in 10 seconds, another question is whether or not the persons complained against have filed their Form 700 leaving office and have in fact left office with the leaving office Form 700. And I think Member Wolf made reference to Section 67.29-1. And Bruce, you might want to read that out loud so I don't have to, because I don't have the time. The intention of that section was in cases where the mayor leaves office, but it can be broadly read that anytime there's a transition of office holders, that the records need to be kept. So just because so-and-so is no longer serving in that office, if there was a record retention requirement, that those records need to be kept and made available so that the records survive the transition from one officer to another. And that was really kind of the idea there. I'm happy to take questions or discuss more. But let's defer to the next person. Thanks.
Thank you. We have other person on the line. They haven't indicated if they want to speak or not, but I'll go ahead and unmute them anyways, and they can still indicate. Hello, caller, you've been unmuted. We'd like to provide any public comment at this time. Hello, caller. I believe you've been unmuted. You have just raised your hand. Did you want to provide any comment at this time?
Doesn't sound like it, Victor. So
Okay. Thank you very much.
we'll go ahead and close public comment for now. We might get do another round of it here. Just real briefly, because the last speaker brought it up, I'll go ahead and read 6729.1, and then I see some of our members want to comment here. But that says all documents prepared, received, or maintained by the office of the mayor, by any elected city and county official, and by the head of any city or county department are the property of the city and county of San Francisco. The originals of these documents shall be maintained consistent with the records retention policies of the city and county of San Francisco. The one thing I just note that seems to be problematic in this case is that it doesn't appear that the redistricting task force would be considered part of the office of the mayor. The redistricting task force are not elected city or county officials, nor are they the head of any city or county department. This section doesn't necessarily talk about appointed officials, so that might be problematic for us. So anyway, I see Member Wolf, and then we'll go to Member Schmidt.
Okay. So first of all, the ordinance and the CPRA are meant to be interpreted broadly, not narrowly. So if we were to interpret it, Section 6729-1 broadly, it would be anything that is maintained by the office of mayor, which would be within the executive branch. Because the responsibility under the ordinance for implementing the Sunshine Ordinance is for the business of the office of the mayor, which is the executive branch. If the mayor never hired anybody for the executive branch and everything was under the office of the mayor, then it would just be in that quote unquote office. Otherwise, it could be any office under the office of the mayor, which is the entire executive branch. That's the way I interpret it broadly. But under the charter, the redistricting task force is convened by the Board of Supervisors. That is very well printed. It's very explicit. So I would think that that would fall under elected city and county officials. Okay. So that's the way I would interpret it broadly. Lastly, as I started out with my original comments, is that we are not taking this in a state of as if the question should be, should we be taking this in a state of when the complaint was made, the request was made at the time that they were active officials, or are we taking it as now the request is after the whole thing is disbanded? And I contend, as we have and do in all our cases, it's precedent for the Sunshine Task Force that the request and the alleged complaint is being referred to at the time that the complaint was made and the request was made at that time, not at the time that we get to hear it, which could be a year later. And I'll stop there.
All right, Member Schmidt.
Yeah, I just want to point out what I think. If I'm looking at one of these cases, there might be several questions that would come up, but the first one would be, I'd be looking at the request itself. And I'm looking at the rule, which is 6721B, which talks about, well, the second sentence talks about how a request may be delivered to the office of the custodian. And so there's a delivery to the office option, and that can be done by email. I guess what we would assume is that would refer in this situation, if you're talking about an individual former member of that task force, that would be the office, which is the redistricting task force itself, which, I'm not sure if they had an office or if that's just the clerk's office. But the first sentence talks about receipt of a request. And so a custodian shall, following receipt of a request. So that's another question that I would have is, was there receipt of a request? And so we'd have to decide receipt by who? Receipt at the office of this task force? Or if you're saying that an individual is a custodian of records, does that mean that that receipt pertains to that individual person? So those are sort of some preliminary questions that might come up in these cases.
Okay, thank you, Member Schmidt. I think these complaints, all of them, if not most of them, or the initial requests were sent directly to the sfgov.org email addresses of each of the task force members. To kind of get to your point, Member Schmidt. So I think they were directed at each one. I think the concern that and to Member Wolf's point, I think that obviously they were the custodian of records at the time. They held the public records. I don't think there's much dispute about that, since we know that these were, initially directed to them back in April. The question would be if we were to, let's say, move this on to, let's say, your committee, member Schmidt, right? And we were to send out notices to each of the task force members who were initially, had the request for them, and they either don't have access to their SF.gov email addresses anymore, and I don't know if the task force even has alternate contact information for them, or even if we do, and we send it to them, and they just choose not to come to any of our meetings and basically just say, hey, I'm not a city official. Good luck to you trying to get these, right? Where does that leave us? I think in many other cases, we've kind of held another city, department or agency to a certain extent responsible for helping the member of the public get those records, right? So if it's, let's say something was with the zoo, we said, hey, Park and Rec, it's your responsibility to work with the zoo to get these records. So is there a city department that has some responsibility to assist the members of the public who need to get these records, right? Should someone be, working with and coordinating with, a current city employee or a city official working with or directing the former task force members that, hey, you have to turn this stuff over to the city. We have pending records for you. You have to show up. Or is it basically each member of the public on their own against each of these, task force members? And that's kind of where it is. So I see, let's see, member Neighbors, member Wolf, and member Schmidt.
Thank you. I think that we should be cautious about letting fear of failure stop us from proceeding in a logical way in alignment with policy. Because it's true, we know that some of those requests, we're calling them documents. We know some of these requests are likely to be for texts, right? Text messages or things that are not even included in SF.gov email, right? Our chances of success we might predict that they would be really low. But that doesn't mean in terms of how we execute our policy that we shouldn't be following the correct steps. It's on us to do the right thing, even if they do the wrong thing, right? We've got to do the right thing. I think that we might be able to expedite our process a little bit by doing both simultaneously, both addressing the request to appear to the individual custodians of records who the violation is alleged at the time, as well as the Board of Supervisors in terms of holding them accountable for them. So I think that we could maybe do that. I think that there's a rationale for doing that. So it's going to the original, but also to their appointing authority, because somebody has to be accountable. And we have to proceed with the notion that we're going to hold somebody accountable, not with the notion that we're going to fail. That's my thought.
All right, member Wolf.
Yeah, so a couple of things is, one, who was responsible for maintaining all of the records for the task force while it was in session? That is my first question. The second question is, did the ordinance creating the... Yes, okay. But my question is answered looking on page P10, is whether this was an actual ordinance or resolution. And it's an ordinance having been signed by the mayor. So the question is it's still that if it was a resolution by the Board of Supervisors to create something on its own, then I would say then the onus is on the Board of Supervisors. But the ordinance doesn't specify. It doesn't go too as far as when on page P7 at the top, starting with line 1, the clerk of the Board of Supervisors shall serve as the secretary of the task force. The clerk's duties shall include, but are not limited to, maintaining the web page, posting agendas and minutes, coordinating meetings, and providing equipment and workspace for the members as needed. And I truncated some of that for brevity. But it's not limited to. So the question is does that also include maintaining, curating, archiving all the documentation and the records for the task force itself? By the same token, who issued their email accounts? And we go back to that same question, were the email accounts backed up? And if they were backed up, then it doesn't matter who curates them, produce the backup, for those records that are being requested. And the Department of Technology has the expertise to be able to do that. I'll stop there.
Okay, I'll go. Yeah, remember, Wolf, to your point, that was the section I was looking at when I suggested that perhaps, the clerk of the board be involved in this. I think first to member Neighbor's point, I'm certainly of the opinion that, I think we need to notice all of the original people who were named. And so I think the question is, to keep these process moving along, do we want to add an additional person on top of each of it, right? So if it was member, ABC, do we want to say, direct the complaint to member ABC or former member ABC, as well as the clerk of the board, Department of Elections, or whomever else? Because it might be frustrating for, if we go through the process naming just the member, and that doesn't get us somewhere, do we need to go back to the beginning then? And the more time that passes, the more chance there are for these records to be destroyed. We've seen that happen. So, I think as much as we can package this up front and get as many potential individuals involved, helps minimize the chance that something gets destroyed. We have to delay this and start over again. And so, I totally agree that I think we should name the member and then some other entity or entities, perhaps. It's just figuring out who those are. So yeah, perhaps it's the clerk of the board, because it does say they'll serve as the secretary. It might be a stretch. But under 6729.7, Part B, it talks about the Department of Elections shall keep and preserve all records and invoices relating to the design and printing of ballots and other election materials. And so, obviously, this is related to elections. Would the Department of Elections have some role potentially in doing it? Because obviously, this is elections related. So I don't know. It's just another possible thought.
Mr. Chair, just a quick thought, and I went to mention this before. If there is some question as to who is supposed to be managing all these records and they're kind of floating in the ether now, then I think it would demand that a subpoena be issued by the Board of Supervisors to assure that these records are held. It could be held by the city attorney. And be collected. At the same time, to possibly freeze those email accounts before they get deleted, and also to send communication to each of these task force members that they should not be deleting public information off their personal devices if they have them.
I see Member Stein been waving her hand.
Yeah, I was just going to kind of come back to my point earlier, which is this is such an unusual body that gets created, and it does seem like several existing sort of agencies of the government have a hand in it and may have records related to it. I'm just wondering if there's a more informal way we can start by reaching out to, whether it's director of elections. I know you have reached out to the Board of Supervisors clerk, and it hasn't been successful so far, but just to even inquire about whether they've retained any records from this, from this particular task force, and rather than go necessarily directly to a subpoena or something like that. I think our first question is, who keeps these records, right? And it may be the individuals who were asked, but because of the kind of multi-part nature of who convenes this task force and who might be supplying them with information and briefings or whatever that they use to make their decisions. I feel like this is kind of a special case where we might want to reach out as a task force, but not through necessarily the formal hearing process, and just inquire to begin with who might have these records.
Okay, see, I thought Member Schmidt, did you have your hand up? Oh, okay. So I guess there's a variety of ideas that we have here, on the table. I didn't know if we wanted to potentially craft a motion to provide some direction going forward. I think the next step obviously needs to be that, these complaints were filed, several weeks ago. They need to show up on a committee agenda, right? And so the first thing we need to worry about is, how do we notice these as they go out to be placed on committee agendas for their initial hearing, right? Do we send a notice and expectation for just that member to show up, or do we notice some other entity or entities that they need to appear as well? I think that's probably the first step we need to take, because until we can make that decision, these are kind of just sitting out there, and we want to get them scheduled at some point, sooner rather than later. Member Schmidt, I think I see your hand now.
Yeah, in terms of that question, it seems like there would be a limitation if the issue is who's supposed to respond to these requests. If the requests are made to these individuals, and as Chair Yankee, you said that if these requests were sent to the individual SFGov accounts, I'm just not sure why you're saying that there should be these other entities that should be sort of like looped in for a hearing if they never got a request to respond to. I'm not quite sure where that comes from, and why would we even be able to justify asking them to show up to a hearing? Is it just to be questioned?
Member Schmidt, to your point, what I was initially looking at when talking with council about this was 6721E, where it talks about the final sentence, where requested by the petition, the Sunshine Ordinance Task Force may conduct a public hearing regarding the request denial. An authorized representative of the custodian public records requested shall attend any hearing explaining the basis for its decision to withhold the records requested, right? So is there an authorized individual here? Oftentimes, we might see a particular, complaint be lodged against, let's say, a department head, but we have someone else show up to argue on their behalf, so to speak, right? And to be that authorized representative. And so is there an authorized representative here that we could compel to come, right? Because we can say that the respondent needs to come, or an authorized representative needs to come, right? Because we don't know, I would hope that each of these task force members would show up, but I think we have to, plan on the fact that they may not. And so we do have the authority to say that they need to send an authorized representative here, right? We can demand that. And so in this case, who would that be? Who would be the authorized representative? I guess is the question that, that I had in the section of the ordinance I was looking at for that. Member Padmanabhan?
Yeah, so I'm trying to get some clarity on this. So even if the member of the task force does show up, and there are two scenarios: one, that the member does have the records, and then it's an easy solution. What if the member does not have the records? How can that member also direct us to the next body? Would it then require us to, in cases, in other cases that we've seen, we've not necessarily had a situation where if a record was not available, we followed the loop, or I've not seen a case such as that. So I don't know if it exists in the past, but could you speak on that?
I'm not exactly sure I understand the question.
So,
Ordinarily, when we try to get records, right, we're having the person someone who is still affiliated with the city, right? So, for example, we've
that's
seen several
the
things,
custodian, right?
right? Several, department head or custodians of records with the Department of Public Health, for instance, that have come and gone, but we'll always have the current one show up and say, okay, I have these now. I've been working to get these together, even though so and so left, so many months ago. So in this case, it's kind of, the opposite, right? Where it's we don't know who that person may be, and there might not be anyone, right? It might be that these records were never turned over, and they may just be with the member or former member.
And if that former member is not willing to release that record, then only that member is held liable at that point.
Potentially, I mean, that's something we'll have to decide is whether or not there's someone else who shares some responsibility in getting those records to the extent that they can. Let's see, I see Member Hill and then Member Schmidt.
Thank you, Chair. Is this relevant? The records retention, the clerk of the board, item number 26 refers to boards and commissions, office records of board members, and the description says office working documents and records received from members of the board upon their department are to be retained by the clerk's office for reference to the following board member. This is not a part of a legislative file. Is that relevant to this? It says the retention category would be active plus a year, total retention period. So the active calendar year plus a year, with on-site retention being 1 year, off-site retention not applicable. But it does mention office working documents and records received from members of the board upon their department are to be retained by the clerk's office for reference to the following board member. And it references Administrative Code Section 867, which I honestly am having a little bit of trouble getting to the bottom of that. But I just wanted to bring that up as a reference, as a possible reference.
Thank you, Member Hill. Member Wolf.
Yeah, but I think that's specifically to the Board of Supervisors, right? So that's
I'm sorry. It's specifically about boards and commissions.
Where do you can you cite the statute again?
So this is, well, I'll tell you where. So that if you go to the records and retention and destruction schedule, motion M14-077 for records and retention and destruction schedule, office of the clerk of the board, and you reference their schedule, and again, so this is records retention schedule by type of the board, motion M14-077, and it's specifically fortunately it's referenced by line. There's a line number for each one of them, and there's a line number that's specific to boards and commissions communications. So there's boards and commissions clerk's office general, there's boards and commissions board office records for board members, and that's line 26. It references Administrative Code Section 867. And unfortunately, I can't, and it's just be my lack of understanding what I don't see a Section 867. So if you could help me find that would also be helpful, because Section 8 only goes to 44. It looks like.
I was going to confirm the same, Member Hill. Don't think it's you.
Okay.
It goes to 44.
So it's referencing a section 67. But I can provide a link to the group if that would be helpful. sfbos.org/records-retention-and-destruction-schedule.
Through the chair, where do you see the reference to 8 point, whatever that section that you're referring to? I only see references to 8.4, 8.3.
I'm going to speak it out loud and for the record, but then also include it in the chat as well. But so we'll have it on the record. sfbos.org.
I warn, please don't use the chat.
/records/retention-and-destruction-schedule.
Yeah, I'm there.
Yes, sorry for interrupting, but please avoid using the chat for any communication, as that becomes disclosable if you do use it, and it's not something that that we encourage you to use, because people listening can't see it.
Hence why I spoke it.
Victor, I have a question for you. Would it be appropriate to share a screen if someone has it on their computer?
You can share it because that is recorded and can be displayed easily. If you'd like to share your screen, you can do that. I can make you I can enable that for you if you'd like to share your screen.
Member Hill, would you like to do that?
Yes, please.
Okay.
Give me a moment. Let's see if I can remember how to do it. You might have, since you are a panelist, I believe you can share your screen.
I'm getting it's a grayed out button for me currently.
Try again.
Okay.
Okay, you are a presenter at this time.
That worked. Thank you very much. All right, give me just a moment.
And I don't know if this makes it, I don't want to speak on behalf of the Board of Supervisors, but usually each department has their own retention schedule, and it applies to that individual department.
So what I'm referring to here is boards and commissions, office records, board members, clerk's office generals, division of clerk's office, office working documents and records received, and then it references Administrative Code 8, Section 67.
It's too small on the screen for me.
Oh, here, I'm sorry. Let me,
It's David Pilpel. Can I chime in for a quick second?
One moment, Mr. Pilpel.
Okay.
Could you make it a little bit bigger?
Of course.
Oh, I'm sorry. That if you look at the character right in front of 67, that stands for
8 and 67.
That's chapter 8 and chapter 67.
Chapter 67. Okay. Right. Thank you very much. The link doesn't take us anywhere, but that is yes. Now you're seeing the actual reference.
I was just going to say the same thing. That's all.
Okay.
Thank you, sir.
Thank you. All right, I see. Let's see, Member Wolf, and then that's it for now. Member Wolf, do you have further comments? I see your hand up.
Yeah, I just I think we need to make a decision as to who ultimately is the overriding custodian as an agency at this point, or a department. I mean, if we back it up to the California Public Records Act, it speaks of agencies responding to requests, not to, as the custodian, not individuals. If we drop it down to the Sunshine Ordinance of San Francisco, we're talking about individuals as being the custodian. And as you pointed out, rightly so, in 6721E, I think it was, that there should be a representative who would speak on behalf. Now, we have, again, precedent when requests were made of a custodian that no longer works for the city, but that subject matter is still being managed and overseen by that department. The representative or generally it's the public information officer that's doing the work, will continue to, they'll basically inherit it, or the new staffer that replaces that person will inherit it. So I think we need to kind of, soon come to a decision as to who exactly is the custodian here. I'm kind of leaning that it's the Board of Supervisors, because they're the ones responsible for convening, and they're responsible for providing the duties in like very specific duties to the clerk of the board as the secretary that are not limited to what is in the ordinance. And so if for some reason this was, here's a hypothetical, this gets the lawsuit is ensued right now, and a subpoena is sent by the court. Who collects the records? Well, obviously it's going to be the legal counsel that's going to be the lead on that, which is going to be the city attorney. So who's the city attorney then going to go to get the records? And it's a hypothetical question. It's real. It's not rhetorical. It can be answered or not. I just want to put it out there, though.
Yeah, Member Wolf, I kind of am in this, the same line of thought as you are. I think that, obviously Smith versus San Jose talks about, I think like you pointed out, that the agency needs to, work to get these records, right? So it doesn't just say, hey, good luck getting from that individual, see if you can track them down. It involves some type of, role for the city or whatever local jurisdiction to play in this, right? And so obviously, I'm not sure how helpful it would be in this case just to say, well, the city and county of San Francisco, right? So that doesn't, narrow it down. So I think we need to name a specific person to your point, Member Wolf, that, if there were a subpoena to the city to get these records, right, who would the city attorney's office work from to coordinate this, right? So my personal inclination, based on reading the ordinance and how that was passed to establish the task force, talking about how the clerk of the board shall serve as the secretary, and how it says its duties shall include but not limited to. I'm personally leaning towards that it's the clerk of the board's office. But maybe other members have different thoughts. Okay. Member Schmidt?
Well, the question is, who would be the custodian per se that is responsible for responding to the request? I would myself think that it would be a more limited scope, because it's only going to be whoever would reasonably be construed to have looked at the email that was sent as a request. If you're talking about, other people who may somehow have the records and, we could summon them, that's a broader category than who's the actual custodian who's being requested on that request, because that's very specific if it goes to a specific email. That's my position.
Member Wolf?
So I would say where there are gray areas, and maybe we can consider this kind of a bit of a darker gray area, I would say that maybe it's worthwhile to engage the supervisor of records, which is the city attorney, because the city attorney is also engaged this task force in complying with the Sunshine Ordinance during one or more of their sessions in writing. I think there's some, I think it would be a fair arbiter, for at least process where it's unclear as to who is the supervising or the umbrella body for this to, maybe be the one to collect the records, or to help direct where those records might be. I don't know, David, maybe you have some insight on this or some on maybe that. I mean, I am more leaning that it's the Board of Supervisors because, again, the charter, which is kind of the law of the land in San Francisco, states that it's the Board of Supervisors that convenes it. The question is it on the administration of it is in the ordinance. The administration is done by the clerk. So as acting as the secretary of that commission. So I'll stop there.
So maybe DCA Reese, you could speak to some of that, and then maybe also give us a little background on if there were, since I think some of these records could very well fall into a Smith versus San Jose scenario. If you could perhaps talk about the role of the individual, since it would be their, let's say, text messages or personal email versus the role of, the agency or the local jurisdiction in responding to Smith versus San Jose issues.
Yeah, so the court decision speaks of it as the agency's obligation. So, I said that, the case kind of stands for the public records that are in someone's personal email or, personal device remain public records. But the way the court decision speaks of it is as, again, meaning that the public agency's obligation to search for records extends to, reaching out to those individuals to gather those records. And then, Member Wolf, to the question you directed to me. I mean, I would go back to the language that you read out earlier from the and that you just referenced, from the ordinance on the redistricting task force that does say that the clerk of the Board of Supervisors serves as secretary, and we could say would be expected to have records, not necessarily meaning all the records, but clearly, again, the ordinance says speaks of sending out the agendas and minutes, so clearly the clerk would be expected to have some of those records of the task force conducting its business.
Well, we're looking for a responsible party here. That's what we're looking for. And I would again say that if there is some concern from us that because these task force members aren't serving anymore, if they felt that and were not given instruction on retention policies, that we find some way to preserve those records immediately. And I guess DCA Reese, I would ask for advice as to how would the task force go about doing that. Now, I suggested asking the Board of Supervisors for a subpoena, which I believe it can do. So I don't know.
Yeah, I'm not ready to opine on subpoena powers. Here, purpose other than I guess I would for the discussion you guys were already having about starting with an agency with custody of some of these records, and then I think it was task member Meadows was speaking about accountability, but finding again, an agency with some records and then an obligation to keep searching for other records responsive to these requests.
I see Member Hill.
Again, I'll just mention section that's come up a lot, section 67.29.1. All documents prepared, received, or maintained by the office of the mayor by any elected city or county official. And I'm just going to take that to mean like officials, and by the head of the city or county department of the property, city, county of San Francisco. The originals of the documents shall be maintained consistent with the records retention policies of the city, county of San Francisco. So I refer to the records and retention policy for boards and commissions that says it's that the person or the office that is responsible for boards and commissions is the clerk's office, and that they are to be retained by the clerk's office for reference. To me, it feels like that it's pointing that section 67.29.1 is pointing to the retention policies, and we're looking at the retention policy for boards and commissions that says upon the departure would be retained by the clerk's office for reference. Thank you.
All right, and I thought I saw Member Neighbors.
I was wondering if anybody had given any thought to, I don't think, I think largely what I'm hearing in regard to, maintaining our due diligence to noticing the commissioners as their, the individual custodians of records, as well as the Board of Supervisors, that I'm in general with agreement of that. And I'm also very interested in what Member Wolf is saying about ensuring that we do everything we can to halt the potential destruction of any records, because that's definitely a risk. And then I just wondered, in looking over the ordinance again, the members have been serving at the pleasure of their appointing authorities, not just the Board of Supervisors overall, right? Like 3 were from elections and 3 from the mayor's and 3 mayor's office and 3 from the city. And at one point, even the elections considered removing their members for, potential or alleged misconduct or whatever. And I just wondered if they were looking at chain of accountability, if there's anything there through their appointing authority, that would be salient. But I think if anybody has any thoughts on that, I'd love to hear them. But I think we are going in the right direction in terms of thinking about the Board of Supervisors in general.
Member Hill, I see your hand. Did you have more questions from last time? Okay. And then Member Neighbors, is your hand back up or? Oh, okay. Okay, so did we want to perhaps formulate a motion at this time, and then we can, take some public comment on that motion and see where that takes us? Anyone want to throw it out there?
One quick thing that we could do that someone pointed out earlier that I don't think we addressed is, could we simply find out if their emails are still active? Is that a question that could be answered pretty easily?
I believe that, this is Victor Young. I believe we did ask that question, and the city email addresses are still active and should remain active for the foreseeable futures.
Okay.
Yeah, so Member Neighbors, to your point, I think they're active, so I don't think they're going away. I think that there's a question though about, are the members themselves logging in thinking they might still be getting email there? And so if we just notice them there, are they receiving, in fact, I'm not even sure if they know that these complaints exist if they haven't logged into those emails for some time, right? So, but I don't think that they were deleted. So I think that's helpful, at least in terms of preserving any records that may be in it.
Right.
Okay, Member Wolf?
Yeah, I'd like to take a crack at at least starting with the preservation of the records part. Now, I don't know where. I'd like to cite the authority by the Board of Supervisors to use its subpoena power, and this is not the first time they've used it. I mean, with the whole current corruption scandal, they've invoked it, and they've invoked it rarely, but they've invoked it before. I just don't know. I want to be able to cite it so that and direct it to them so that it's clear. And I was looking in the charter. I just don't see it there. So I'm wondering if it may be somewhere else. I can't quickly find it. I don't know if anybody else has, but maybe I'll just cite it, and then it'll be up to the city attorney that works with the board of supervisors to help, or the supervisor themselves might know to suss it out. So I'll take a crack at it. I moved
Member
to
Wolf, not to interrupt you, but to answer your question.
Yeah.
I found the rules of order for the board.
Okay.
And in section 3.3.1, it says issuance of subpoena duces to come by the government audit and oversight committee, and it says by oral motion adopted by a majority of the members of the government audit and oversight committee. During a subject public hearing, the committee may instruct the clerk of the board to issue a subpoena to individuals whose testimony is sought in that subject public hearing. So maybe that's, and it also says, and respond to questions, produce any related materials in their possession on the hearing matter. So there is that one there. So it might be that we.
Let's see. So it's 6.7.
There's also, I was just about to say, there's also 6.7 that talks about subpoenas.
Okay, so all right, let me back this up for a second. We have a section of the ordinance that authorizes the Board of Supervisors to expand our powers. But we're really not asking for that. I think I'll just go with this. All right, that's good. So I would move that the Sunshine Ordinance Task Force request the Board of Supervisors to issue a subpoena under its rules of order. I don't know whether to cite that section or the other section, or maybe just say rules of order and let them choose the right section as appropriate. How about that? To order all records and communications in every medium regarding the redistricting task force to be retained, and that communications to the task force members, instructing them to retain any and all records, including electronic records from their email accounts, text messaging, or other what's that word? Other types, as per Smith versus San Jose. If somebody will second it, then we can wordsmith it.
I'll second it. This is Member Neighbors.
Okay, so we have that motion made by Member Wolf and seconded by Member Neighbors. Would it be helpful for Cheryl to read back what she has as a starting point for discussion? Okay, go ahead, Cheryl.
Moved by Member Wolf, seconded by Member Neighbors, that the task force requests the Board of Supervisors to issue a subpoena under its rules of order as appropriate to order all records and communications in every medium regarding the redistricting task force to be retained, and that communications to the redistricting task force members instructing them to retain any and all records, including electronic records from their email accounts, text messaging, or other types as per Smith versus San Jose. Was that it?
Yeah. I would change maybe regarding the redistricting task force. I mean, I would maybe saying, I don't know, something like records created. You know, it's really the records that are in the possession of or created.
Instead of regarding the task for redistricting.
Hold on, or instead of regarding, yeah.
Yeah.
In possession of, created by, received by, you know, that whole list of possession type of language. Because if you say just regarding, that means that we're asking what information does the Board of Supervisors have in their own possession. That's not what we're asking for.
Shall I read it again to make sure it's clear?
I'm just waiting to see if there's any other input on what that kind of appropriate language should be.
I see Member Schmidt has his hand up. Member Schmidt, did you want to speak? This?
Well, yeah, I just want to mention, I'm going to myself have to vote no on this one because I think it's pretty far outside the scope of what we were notified that we were considering tonight. I think that it was pretty clear what we were supposed to be deciding. So just to put that on the record, that's all.
Okay. So the agenda item for this says determination of authorized representative of the custodian of the public records and or a successor custodian of records for redistricting task force members pursuant to admin code 67.21 and the development of a process to hear complaints filed against members of the redistricting task force. So that's what was agendized on this to refresh everyone. Member Wolf, I would ask if we're going to formulate this motion, do we want to send it to the entire board, or do we want to send it to a specific committee like Government Audit and Oversight Committee?
No, send it to the board, and then the board will assign it appropriately according to their rules. I don't want to overstep by assuming I know how their rules work.
Okay, so I think we have a motion and a second, so it's an active motion now. Members, do we want to discuss this further, or should we go ahead and proceed to public comment at this point? All right, not seeing any hands, so we'll go ahead and open up public comment, Victor.
Hi, this is Victor. At this time, if you'd like to provide public comment and you're calling in, you can press *3 to raise your hand. Once I unmute you, the system will indicate you have been unmuted. You may begin your comment. Again, if you'd like to make public comment on this matter, please press *3 to indicate that you would like to raise your hand and speak for public comment. Cheryl, are you ready for public commenters?
I am.
Okay. I will unmute the next caller. Once it states you're unmuted, you may begin your comment.
David Philpell again. So interesting discussion, several thoughts. I did do a little research while you were chatting. It appears that member Townsend, or Chair Townsend of the redistricting task force filed a Form 700 annual on April 1st. Member Vice Chair Reiner filed a leaving office Form 700 on May 26th, indicating that she had completed her service. That was just interesting to me. Chair Townsend does not appear to have filed a leaving office Form 700 at this point. The redistricting task force does have a 3-page set of bylaws that are on their website. Hard to find, but they're there. On page 2, Article 5, Clerk, Section 1, Clerk, the clerk for the task force shall be the person designated by the clerk for the Board of Supervisors. Clerk shall attend all task force meetings. The clerk shall be responsible for the proper recording of all task force actions, correspondence, agendas, meeting minutes, and other duties assigned by the task force as chairperson. The clerk shall also be responsible for transmitting communications between the task force and members of the public. That's the closest, in my view, that it gets to records. There is no section that I found about records and record keeping. Sometimes that's in bylaws, sometimes not. I actually very much like Member Wolf's idea involving the supervisor of records. I recall some years ago, I can't remember for sure if the task force actually referred a matter to the supervisor of records. We may well have when I served on this task force. And it may be that Paula Jessen, who at the time was serving as supervisor of records, masterfully resolved the issue without the task force having to weigh in. In this case, you might well suspend proceedings on the complaints, refer them in some manner to the city attorney in their capacity as supervisor of records, and Brad Rusty or whoever is handling that function right now can have fun trying to sort out the different issues here. Fundamentally, I think that this task force should consider making a written request of the city attorney for guidance, public, to issue a public opinion on whether and how either the task force or members of the public that are seeking records can do so when the individual in question, whether an officer or employee, has left city service. I think it's a very important and complicated legal issue. If I can just conclude quickly, the charter section that I think you were looking for about subpoena power is Charter Section 16.114. And fundamentally, I think this is really both about the theory, as I referenced in the suggestion about getting written city attorney guidance or an opinion, and really the practical considerations here. And what I suspect, having not yet read any of the actual complaints, is that whoever is looking for records is not looking for stuff that's already on a website, but probably has a theory that there was communication between one or more members of the redistricting task force and other actors, whether they were activists or the mayor's office or whatever their theory. And the only way to play that out is to determine if the member of the redistricting task force had contemporaneous records at the time of communication, if they've preserved those records, and if they are segregable and disclosable with or without redaction. There are complicated principles there of privacy and electronic stuff, and how deep and how far, particularly if they're not currently in office. That's why I suggest that the supervisor of records or the city attorney, by way of opinion, and not just, the other David here figuring it out, which is good too, but there are a lot of layers to this. I'm not disparaging the other David. He's a member of the David Caucus. We all work together. But this really is complicated, and it has both these theoretical but also these very practical considerations. Unless you have questions, I hope that helps. Thanks for listening.
Okay, thank you. Victor, do we have any other public commenters?
Yes, we have one additional caller who's just raised their hand. I will unmute you. Upon noticing that you have been unmuted, you may begin your public comment.
Can I have your name, please?
Yes, I heard somebody say something. What was that?
That was me. I didn't know it was you, Mr. Warfield. Are you ready to begin?
Yes, I am.
Go ahead.
This is Peter Warfield, Library Users Association. I think it's a very good motion. I do think that you might consider perhaps as a separate motion and perhaps even at a separate time, but I think that there was discussion about notifying folks who have, in a sense, put you in this position of being unclear and having to have a rather lengthy discussion, almost 2 hours now, with regard to the questions that you're raising. So I think that you might want to notify the supervisors, the clerk, the city attorney. I'm not sure who you would want to notify, but when short-term or temporary or specific purpose bodies are formed, there needs clearly to be clarity about who is responsible for the records, who is responsible, and so on, and also what's expected of the members who may very well not be familiar with what the law says, what is required of them, and so on and so forth. Thank you.
Thank you. Are there any other members of the public who wish to provide public comment? You can press *3 to raise your hand at this time. Seeing no other hand raised, I believe that completes public comment.
Okay, thank you, Victor. Members, do we have any last comments or discussion points before we go ahead and vote on this motion? Member Wolf?
Yeah, I'll just say I'm not in favor of engaging the city attorney to make a written opinion, because if it's not an opinion, because it's such a gray area, if it's not something that will help facilitate our work, then that would be very hard to undo. The city attorney's opinion without any overriding law becomes the law. It has the gravity of the law. So it'd be really hard to reel it back. I would just as well move forward with any other instruments that are available to us to be able to try and protect and preserve the records from destruction, so that we can adjudicate these cases as they were brought to us for that work. So in light of what Member Schmidt had said, I'd like to amend the motion by stating, so I move this amendment to the original amendment, seeing that the Sunshine Ordinance Task Force cannot identify an authorized representative, the process shall begin and may be amended as necessary to request a subpoena from the Board of Supervisors on behalf of the Sunshine Ordinance Task Force under Charter Section 16.114 to, and then the original language that I had presented before. And then at the end of that language, and the complaints commence by the assigned committee and that committee to implement the subpoena.
Cheryl, I know that was a lot. So when you're
I
ready,
don't know where he was. Were you reading from text, Bruce?
Yes, I was.
Yeah. Okay. Moved by Member Wolf to amend his motion that this amendment seeking that the task force cannot identify an authorized representative and may be amended as necessary.
No. Seeing that the Sunshine Ordinance Task Force cannot identify an authorized representative, the process shall begin. Well, wait a second. Let me back that up. How about this? The Sunshine Ordinance Task Force recognizes that the Board of Supervisors, having convened the redistricting task force and ordered the clerk of the Board of Supervisors to be its secretary to manage its administration, a subpoena shall be requested from the Board of Supervisors on behalf of the Sunshine Ordinance Task Force under Charter Section 16.114 to, and then the language that is part of the then you have the language from the original original motion. And then after that, at the end of that, to then add, and the complaints and the complaints commence by the assigned committee, and for that committee to implement the subpoena. Okay, this is a really long motion, but
Member Wolf, maybe it'd be better if we, instead of trying to amend what was originally there, maybe we rescind the initial motion and kind of start from scratch.
okay, you can do that.
Are you are you rescinding your motion, Member Wolf?
Yes, I'm rescinding it. Okay, so then I'll break it down into 3 motions.
3 motions?
Yeah. Or 3 parts of a motion. I don't know how else to do this. So let me just speak it out and then see if we can see what people think. So the first part is to find that the secretary of the redistricting task force, who is the clerk of the Board of Supervisors, is the authorized responsible party for the administration of the redistricting task force. 2 is requesting the subpoena to preserve the records. And 3 is that the complaints shall commence, and authorizing that committee to manage the subpoena.
Okay, I did not get all of that, Bruce.
I get that. We're just putting it out there for discussion right now, so we can formulate whether this should be 1 motion or 3 motions.
Okay, this is Chair Yankee. I agree with I think that it's good to name someone, and I think naming the clerk of the board in this scenario makes sense. I think the ordinance speaks to that. I think the bylaws speak to that. And so I think I would, part of the motion, I would think it might be helpful to say to add or include the clerk of the board as an authorized representative, and also continue obviously to notice the individual members as well. And so we can get, both of them together. And then I think we can ask for the subpoena. Maybe it's getting a little ahead of ourselves to say how we're going to act on that subpoena, since that's not something that's happened yet. But and I'm not sure we necessarily even need to have that as part of the motion. So maybe we just make it two parts. Maybe we find that the clerk of the board should be added as an authorized representative to each of the complaints as noticed as such. And then part two, that that we request a subpoena from the board of supervisors to preserve any records or correspondence in possession of the redistricting task force.
So I just have to ask, and this is for the lawyers in the room, when a subpoena is issued, who is administrating it? Is it the party that asked for requested the subpoena? Then they're the ones that monitor it and make the request for certain records under the power of that subpoena.
I'm not totally sure if I understand the question, Member Wolf. I mean, I guess, just two things in response. One, I mean, it's supposed to be specific enough that someone receiving the subpoena, knows what's being sought. But as far as the who, I mean, I think here, if we're referencing that it's the board's authority to issue the subpoena. So I think that it would be.
I guess what I'm asking is once the subpoena is issued, then if the complaints commence by, I guess it most likely would be the complaints committee in our case, if the complaints committee finds that there were records that were destroyed, that the complaints committee would then, make a reporting of that, or monitor it, or follow it, or chase it down the rabbit hole, or at least there'd be somebody who is seeking that. I not necessarily in this case sure how a subpoena should operate versus how it might operate in court, if a court provided the subpoena.
Still not sure. I mean, so it often a subpoena is issued, I mean, either to have records delivered to, in civil practice, typically to the subpoenaing party, in criminal court, it's subpoenaed for delivery to the court itself.
Well, here we're asking folks not to destroy records so that the records that are being requested can be disclosed.
So I can just, typically a subpoena means, request delivery or, commands delivery of records.
I'm open to suggestions here.
Member Stein? Member Stein, you're on mute.
Yeah, hi. I'm also not sure why we're jumping straight to the subpoena idea when it doesn't seem like we've talked to anybody who, except for, I guess you have that one letter to the clerk's office, but to anybody who may be holding these records. Can we not just send a note saying all this, but without a subpoena, saying we expect that if you have records, you need to retain them. They've been requested. We think you may be holding them as, one of the parties involved in this particular task force?
So Member Stein, each of the task force members named in the complaint has already been notified that a complaint exists. So they know that a complaint's, been filed, that the records have been requested. And obviously that triggers the fact they shouldn't delete them, right, when there's a pending thing. Now,
Right.
you
So
know,
I guess I'm confused too, because I haven't seen any of these requests, and I just don't understand why we're even going this direction right now with assuming that records are going to be destroyed or that we have to, in this kind of subpoena language, raise this issue with, the possible agents that may be the custodians of records.
Well, because we don't know who the responsible party is for maintaining and curating all the records. We don't know if the clerk has been the person that's been doing that. And these folks assume that they're not in service anymore. And so if they figure they're not in service anymore, then they can delete whatever they got. They're done. And what we're trying to do is preserve it before it all goes away.
It's not clear to me why they would think that, when clearly if they're acting in a public capacity and they've produced documents that are, part of their public work, why they would think that that is no longer a public record. But anyway, I'm just confused, like, why we're going this route, and I'm not sure if it's the most effective way to answer, to get to what these complaints want, but I haven't seen these complaints.
Yeah, I see Member Pavanabhan. Oh, I think you're on mute still.
Yeah, I agree with Member Stein. If we're going this route, maybe we should split it into two motions. It's just that I do believe that records are, need to be retained for a certain duration, and that is probably specified. So that's where I stand.
Okay, I see Member Hill.
Thank you, Chair Yankee. Once again, I'm asking the question, does line 26 pertain to this? David, Chair Yankee, could someone just say yes or no, please? Like, I would love just to know if I'm barking up the wrong tree, but it says here office working documents and records received from members of the board upon their departure to be retained by the clerk's office. This is in regards to boards and commissions, boards members. Is this not relevant? Because no one's talking about this. Or is it relevant and no one's talking about this?
I think that's for each of us to decide. We all may interpret that differently. So, I mean, I could give you my thoughts, but
I would love your thoughts, Chair Yankee. Thank you.
My personal thoughts. I'm not sure, but I don't think it's my personal thoughts. I'm not sure we need to even worry about that, because to me, the part of the ordinance that says that the clerk of the board is the secretary, and then the bylaws that Member Pilpel brought up talking about how the clerk should be responsible for transmitting communications between the task force members of the public, and that the clerk's responsible for correspondence. To me, I think all that points enough to you not even have to go to that question, because I think it's even a trickier question. So I would just say that based on that part alone, I'm convinced that it makes sense to add the clerk of the board as an authorized representative for the purposes of moving these complaints forward. And I would agree with, I think Member Stein and Member Pavanabhan, that I think it makes sense to consider these as two different motions. I think they're two very different topics, and I think, we should probably knock one out before we, do the other one. And I think combining them makes it a little bit convoluted here.
I appreciate you speaking up about that. And again, the only reason I'm bringing it up is because there are a lot of people here that are referencing records retention, who's responsible for holding the records. And I'm just simply going to the records retention policy that's set forth by motion M14-077. That's sitting in front of me.
Yeah, my concern about that would be the part that referenced, we can only rule on parts that are under the Sunshine Ordinance. So there's part that talks about Section 8, and so there's, it's kind of a, where does our line go as far as talking about and ruling on records retention matters, right? We don't obviously usually review records retention schedules and so forth. We recognize that each department has to do that. If there are records that are retained, that they have to turn them over, but we don't ordinarily hear cases on whether or not the record retention schedule is like an appropriate record retention schedule or not. That tends to go a little beyond perhaps our authority.
But I appreciate that, but it sounds like what we're suggesting is that we're asking them to hold records. Like, so the Sunshine Ordinance Task Force is asking them to maintain records because there are items coming before us. Whereas what I see here is a retention policy that states that the clerk's office needs to keep records of board members upon their departure. But it sounds like to me what you're saying is that like that's not in our jurisdiction.
Maybe. All right. You know what? Here what? I'll go ahead and make a motion just so we can wrap this part up, and I'll move that we find that under 6721E that the clerk of the board's office be added to each of the pending complaints against the redistricting task force.
Yeah, Matthew, I'm trying to keep up with this.
Okay.
Under 6721E.
Yep. That the clerk of the board's office be added to each of the pending complaints against redistricting task force members as an authorized representative.
Each of the pending complaints, what?
Yep.
Yeah.
Okay. Pending complaints against each of the redistricting task force members as an authorized representative pursuant to Ordinance number 94-21, file, which is also file number 210606, and the redistricting task force bylaws, Article 6, Section 1. So I'll just leave that motion there if anyone wants to second it.
I'll second it.
Okay.
Member Wolf.
All right, Cheryl. So that's moved by Chair Yankee, seconded by Member Wolf. And if you want to go ahead and read that back just to make sure we got it correct.
Moved by Chair Yankee, seconded by Member Wolf, that under section Administrative Code section 6721E, that the clerk of the board, that the clerk of the board's office be added to each of the pending complaints against each of the redistricting task force members as an authorized representative pursuant to Ordinance number 94-21, file number 210606, and redistricting task force bylaws, Article 6, Section 1.
Mm-hmm. Yes.
Okay.
Okay. So now we have a motion with the second. Any discussion, members? I see Member Hill. Oh, okay, not Member Hill. Okay, let's go ahead and move to public comment. If there is any.
Yes. If you would like to make public comment on this at this time, you can press *3 to raise your hand. We do have one person already in line to speak. I'll go ahead and unmute them.
David Philpell again, just very briefly to Chair Yankee. I think your reference to the task force bylaws is more accurate in Article 5, Section 1, not Article 6. Article 5 is clerk, Article 6 is meetings. Otherwise, I think I am good with the motion. Upon more discussion and a little reflection on my part, and in part to Member Wolf, I'm thinking at this point that all the discussion about subpoena and record preservation and all that is perhaps premature. You haven't held a hearing on any of these complaints. It may well be that the respondent actually, or respondents actually have records and are willing to produce, or that there's some other way around it or through it. I think depending on how the hearing on the merits goes when you get to that, then you'll still have lots of options and considerations. And at that point, if you need to go nuclear or go whatever, you'll be able to burn that bridge when you get there. So I think the motion that you're now considering seems like a reasonable step given what you know and where you're at in the process, and the rest we could probably just put aside for the moment. But let's see how this goes. Anyway, those are my thoughts. Thanks again.
Okay, thank you, Mr. Pelpel. Any other public commenters?
Okay, we have one other caller on the line. If you'd like to make public comment at this time, please raise your hand. I want to unmute you for public comment. If you would like to comment, please press *3 at this time. There's no indication. I do not believe they would like to make comment at this time.
Okay, thank you, Victor. Okay, and Cheryl, Mr. Pelpel's correct. I actually, when I had Googled the bylaws, I had somehow brought up the 2011 task force bylaw, redistricting task force bylaws, and so it looks like the section changed in the 2021. So instead of Article 6, can you change that to Article 5? That's just a clerical.
Yeah, got it.
Okay. So thank you, Mr. Pelpel, for that. All right. Members, any discussion before we go ahead and vote on this? Okay, seeing none. Cheryl, I think we're ready for a vote.
Okay. Hold on a second. Chair Yankee?
Aye.
Sorry about that. Chair Yankee, aye. Member Wolf?
Aye.
Member Wolf, aye. Member Schmidt?
Aye.
Member Schmidt, aye. Member LaHood? Absent. Member Padmanabhan?
Aye.
Member Padmanabhan, aye. Member Stein?
Aye.
Member Stein, aye. Member Highland? Absent. Member Neighbors?
Aye.
Member Neighbors, aye. Member Hill?
Aye.
Member Hill, aye. Vice Chair Wong, I believe, is still absent. Okay, so do you need me to read it again, Chair Yankee?
Sure, why don't you read it again and then read the outcome of the vote?
Okay. Moved by Chair Yankee, seconded by Member Wolf, that under Administrative Code Section 6721E, that the clerk of the board and the office of the clerk be added to each of the pending complaints against each of the redistricting task force members as an authorized representative pursuant to Ordinance number 94-21, file number 210606, and the redistricting task force bylaws, Article 5, Section 1. Is it still Section 1, Matthew?
It is still Section 1, yes.
Okay.
I think we're all set. And then the vote total was?
Okay. 1, 2, 3, 4, 5, 7. We're good.
Okay, so 7. All right. Any other motions or discussions on this item? Okay, seeing none, we'll go ahead and move to the next item. So Cheryl, when you're ready.
Item number 3, hearing, presentation/discussion of the text of bills AB 1944 and AB 2449.
Okay, and I know this was a topic that Member Wolf had brought up, and I believe Member Neighbors added some discussion points as well from our last meeting. So this is a topic that we continued. So I'll turn it over to Member Wolf and Member Neighbors if they want to add additional information on this item.
Okay, and also DCA Reese had also made presentation on these.
I think he did the presentation at our last meeting, unless he had additional information to share.
Yeah,
since our last meeting.
The only information, there hasn't been any additional amendments that I can see. It has taken the Senate Rules Committee a couple of weeks here to get it assigned. It is now 1944 is assigned to Government and Finance Committee and a second committee, the Judiciary. So it's got a little ways to go. Again, the main issues in this, if you read the text, is that it would allow meetings to be held in their entirety remotely, and that it could be held at a location that may or may not be accessible to the public, and it may not be revealed. The location may not be revealed publicly if it's wherever a member of the body is. So if you have 2 or 3 or 4 members of a body that are in one place, and maybe it's at somebody's house or at somebody's office, then under this bill, they would not be required to reveal where that is. And so if also if they were all to meet in a private location, that the same thing could happen. And if the technology goes dead, they may very well be able to continue the meeting. It's not clear in the legislation of what happens in those scenarios. So you never know what's going to happen if something like that happens. This will not commence until 2024. I believe that's when AB 361 sunsets, and it would be repealed in 2030. And then the second one, AB 249, that one is more geared towards allowing those legislative body members who are requesting reasonable accommodations to continue to meet remotely. So it preserves their ability to do that, and it provides some other guardrails which are not really that they kind of flow with what we already have in our ordinance. The third one was for the Bagley-Keene Act, and I don't know if that necessarily pertains to us, but that one seems to be stalled in committee. So that's it. I don't know if anybody else has anything to add.
If I may, I just had one point from the discussion last meeting, because there was follow-up discussion amongst members about possibly like taking a position as a task force or writing a letter. So I did want to caution on that, just that that in San Francisco, with our strong mayor system, that all like positions and advocacies are meant to go through the mayor's office of legislative and government affairs. So it would be a recommendation that if the task force did want to take a position or advocate amongst these bills, that be directed at the mayor's office, and that it is that office within the mayor's office that then does perform kind of a lobbying or a legislative advocacy function on behalf of the city.
Yeah, we wouldn't take a position. We would be making a recommendation, and actually we would identify the state legislation committee, which is a collective, including the mayor's office. That's how those decisions get made. So from what I understand. So I will put forward that I think we should, this should be on watch. I don't think the city should take a position to support it. because there's lots of activity happening from advocacy groups and most likely other cities too. So I think at this point we should recommend that the city take a position of watch.
Take a position of what, Bruce?
Watch.
Oh, thank you.
I would just have a question that Mrs. Chirianki, does that committee that you referred to, Bruce, or member Wolf, do they watch all bills? I mean, is it necessary for us to take an action to say watch it? I mean, would they ordinarily be watching it anyways, or should we, if that's something we want to do, should we formulate an actual motion to recommend that?
I've spoken to representatives of supervisors who sit on that committee, and it's not even on their radar. There are thousands of bills, so it's common that something might not get picked up, and if they saw it early on and then decided, okay, there's no there, or there's not much activity, then they might not even watch it. Is there other more important high-profile items?
Okay.
The question I have for folks is, in reading this bill, does any of it concern you? This will, make permanent changes to the Brown Act, of which we oversee through 2030, and that's at least for 1944. For 2449, it would make it permanent unless it was amended or repealed in the future.
I think I saw Member Stein's
Yeah,
hand
I
up.
was going to say I'm a little bit confused because maybe I'm not reading it clearly, but your summary doesn't match like my notes for instance, for AB 1944, because it looked to me like it was saying that there had to be a quorum as of January 1, 2024, a quorum of members participating from a single location physically that is clearly identified on an agenda open to the public and situated within the boundaries of the territory. So I thought what this bill was trying to do was kind of give a little bit of updating of the teleconferencing language in the law, essentially sort of updating the law to reflect the fluidity of kind of the virtual spaces that we're in right now because of the pandemic when we hold these meetings, which doesn't quite fit the teleconferencing language anymore. And it seems like to me, like it's trying to make the meetings more accessible and in the short term, give a little more flexibility to how members will attend, but not that it's allowing people to indefinitely attend from different spaces without an opportunity for the public to be in those spaces.
I hear what you're saying through the chair. I hear what you're saying, but if you read the first part of that description, it allows members to be exempt from identifying if they're operating by teleconference. There allows them to be exempt from identifying that location. And if one or more are meeting in the same location, then you have a serial meeting happening. They're talking to each other without being presented publicly. If they're in
I thought these
chambers,
have to be agendized meetings. I mean, I don't know. I'm not following, like, from my reading of it and what you're saying. Like, I don't get that.
I'm trying to.
I mean, aren't we now in a teleconference meeting and our locations, like nobody knows the location that I'm at. And I thought that it's just trying to let that continue, that if we're meeting remotely, these teleconferencing rules as they exist that would say that you have to know the location of every member doesn't apply.
I hear what you're saying. The question is whether people who may be congregating together that are less than a quorum are having a private meeting and making decisions offline together that could affect the outcome. This was the whole thing around what happened with the redistricting task force. Even though they met all in the same room, when they took a recess, the city attorney explicitly wrote them a memo saying you cannot meet together, talk to each other, or anything like that during a recess. So I'm concerned, the concerns that are being brought up by the First Amendment Coalition, the ACLU of California, and a number of newspaper publishers is that there could be of less than the quorum that is sitting in the room where you can attend, that the rest of the members could be meeting privately and mounting a voting block outside of the public view. And if they're going to be meeting together, if let's say 3 members out of 7 were to be meeting at a single location, and the public does meeting.
Sorry, you cut out.
You froze for a minute, Bruce.
If 3 members met,
if 3 members met
somewhere, then what?
If 3 members didn't constitute a quorum,
Mm-hmm.
but if 3 members had met remotely in the same location, and they were able to confer with each other outside of the view of the public, that would constitute a serial meeting.
So which one of these, so one of the bills I think talked about that, right? And said that you had to reveal who else was with you in the room. Was it the AB 1944 or was it the other?
It was the
It was 2449.
2449.
No, and Member Neighbors has had her hand raised for a while too, so I want to make sure she has an opportunity to talk in here as well.
Go ahead.
This is really interesting because I had the same reaction when Member Wolf was summarizing the bills that I felt I wondered if I had the wrong bills in my hand. And I read them more as Member Wolf had read them, and certainly the way I marked them up is more in line with that. And I really the language of it is about individual members participating remotely, and the safeguards are there in terms of, and this makes a lot more sense now because I thought, this was kind of a weird invasion of privacy. For instance, the member shall publicly disclose at the meeting before any action is taken whether any individuals 18 years of age or older are present in the room at the remote location with the member and the general nature of the member's relationship with any such individuals. That kind of safeguard seems to be there specifically for the reasons that that we might be fearful of in terms of serial meetings. And another example is a member shall participate through both audio and visual technology. I think that it's actually it's attempting to address the potential of serial meeting violations by putting those safeguards up, and at the same time getting realistic about the future before us with remote meetings. So I really read it with that. The other one, I think, I didn't think was as strong. I felt that it just wasn't as, it didn't, actually, that's the one that gives us stipulations. Yeah, that's 24. The other one, though, I felt was left too many, like a few kind of loopholes in particular in terms of how Member Wolf is describing the concern for serial meetings. So but in terms of action, given what you're saying about the lack of assurance that that anyone else will be watching them, I would rather that we make sure that we keep them on our radar and that we're tracking the changes. And we know that these bills go through so many changes and as they go through the pipeline. So could we not track them ourselves, keep an eye on them ourselves? We seem to care more about these issues than a lot of other folks.
I see Member Wolf.
Yeah, I would just respond to say that, yeah, nobody pays attention to these until the sausage is made. And then once the sausage is made, it's too late. And, right now everything is happening very, very quickly. So more amendments can come on the Senate side that can be even worse. And so the question then becomes, how do we help represent, a good, strong, open meetings law? If it starts to degrade because the legislature wants to do more work in secret, or wants to allow, it's not legislature actually, wants to allow local governments to do, to have more flexibility, and it ends, and the collateral is that there's more meetings being done, or let's say less access to the public. It reduces access to the public. Then what? Are we really being a good watchdog? I think we need to do more than just track things.
So would, beyond asking someone else to track them then, Member Wolf, is there another option that would be more concrete that we could take?
Well, the action would be to have the city to recommend from the body that is supposed to be watching these things too, from the people's point of view, to recommend a position. And if it conflicts with the positions that they're taking, then they've got a debate going on. And that's what, that's important. So otherwise, if we don't chime in, then it's like, okay, I guess the Sunshine Task Force isn't interested in the laws that they oversee, which feels not good to me personally and professionally. So that's why I said that, I mean, the coalition that is advocating for as much transparency as possible and access, they're taking an opposed position of 1944. Okay, I'm suggesting we take a watch position, which means that the city doesn't take a position yet. That's what we're requesting them to do, is don't support it, don't oppose it, but watch to see what amendments come up. And we'll track it, and if we'll do a follow-up, but at least it gets it on their radar, and it gets our voice there. It raises our profile with them too. And I think that's important. And I'm saying watch for both bills at this time.
Would it make sense to write a letter saying we'd like you to watch this and here are the concerns that we have?
That's what I'm suggesting, is that we make submit a recommendation for them to take a watch position.
Outlining
for
our
these reasons.
outlining our specific concerns.
Yeah. And it could be just simply that we're concerned about any changes to the Open Meetings Act that seems to be working okay now. Under AB 361, we've already been down that road, and we've outlined, issues with that. The question is do these laws further, do they increase access or they decrease access? And that's what I think that's what our concern is.
Okay, so it sounds like, does anyone want to make a motion on this item?
So I'll make a motion, just get the ball rolling. I move to send a memo to the State Legislative Committee, San Francisco State Legislative Committee, to take a position of watch for bills AB 1944 and AB 2449, as they will affect the implementation of the Brown Act. And we will provide further recommendations as the bills continue in their process.
Okay, so we have a motion. Does anyone want to second that? Any second for Member Wolf's motion? If there's not a second, this motion will die. Okay, I'm not seeing a second on this one, so.
Is there an opportunity to perhaps, I know we don't do friendly amendments, but whatever we do that are basically friendly amendments. I'm wondering if the reason there's not a second is because there needs to be a little more meat around who's going to be writing the memo, how much of a position it will take, and if we as a body can review that before it gets sent. And if we could fill those blanks in, I'd be happy to second it.
That was kind of my hesitancy as well.
My recommendation would be that, so I think this is a fairly brief subject. We're just taking a watch position. I mean, if we're going to get into details, I think that needs to, we need to designate an author. But if it's simply saying, the Sunshine Ordinance Task Force, then I think this could actually come from our administrator and just say, please be advised that the Sunshine Ordinance Task Force passed the following resolution, and we can put the language we want right now into the resolution. And so if the language is simply, please watch these two bills and we will provide further updates, then I think it could just be essentially a copy paste for the most part of the resolution, and there's no letter writing to worry about. I think that's a good point. So
I'm not asking for them to watch it. I'm asking for them to take a position of quote unquote watch.
I'm sorry, yes, take a watch position on the bills. So I think as the resolution or as the motion is currently stated, I think that's, maybe we could clarify it, but to me that's I don't think it authorizes any additional letter writing necessarily.
So just forward the resolution.
Yeah, just forward our resolution. And so maybe we just add that to the end of the language and just say, and direct the administrator to forward a copy of this resolution.
Okay.
What do you think?
Then I will second that. Yeah.
Thank you.
Okay, Cheryl, did you want to go ahead and reread the motion there?
Yeah, a second.
Okay.
All right, I'm going to take a shot at this. Moved by Member Wolf, seconded by Member Neighbors, to send a memo to the San Francisco State Legislative Committee to take a position of watch for bills AB 1944 and AB 2449, as they will affect implementation of the Brown Act and will provide further recommendation as the bills take their process, and direct the administrator to forward a copy of this resolution
To the San Francisco State Legislation Committee.
Okay, Member Wolf, Member Neighbors, does that sound good to both of you? Sounds good. Okay, great. Any discussion amongst us? If not, I'll go ahead and open up the public comment. Not seeing anything. So Victor, when you're ready, we'll do public comment.
Yes, if you'd like to make public comment in this time, please press *3 to unmute, to raise your hand so that you can be recognized. If you'd like to make public comment, hit *3. We do have one caller in the line for public comment this time.
David Philpell again. I think I'm still alive. I'm not quite sure why.
David, hang on.
Oh, okay. That'll be very important in the future for the record. Never mind.
You ready?
Unfortunately, yes. Yes, I am.
Go ahead.
All right. So on this issue, I agree with the motion. I think a memo to the State Legislation Committee requesting that the city take a watch position is appropriate. I might also suggest to Member Wolf to seek amendments. And to that end, as I read the legislation, it seemed to me like the two things that might be eminently reasonable, as these bills would apply to all local legislative bodies throughout the state, are to require that when meeting in a teleconference session, that all documents related to the meeting be posted on the body or agency's website in an appropriate, relatively intuitive location and not obscured somewhere. So whereas in a regular meeting in the old days, if they had some document to share with the public, they'd make 20 copies and dump it on the table in the meeting room. Well, you can't do that if we're meeting online. You guys are all at your locations, which is fine. But an agency can, and in my opinion, should post all of those documents on their website, so everyone can be reading from the same material. That's one specific, and the other is to require agencies, when using teleconferencing for meetings, to specifically amend their bylaws, rules of order, or other meeting procedures to both require that documents be available and to make clear how the public can participate and what to do in the event of a technology breakdown, to address the issue of teleconference meetings specifically in an amendment to their bylaws, rules, or procedures. And that too seems to me like something that they could require each agency to do. Each agency should do that, and the specifics of those changes would relate to how that agency operates, and number of members and territory and subject matter and closed sessions and all kinds of specifics, but that they should update their rules, given that this seems to be part of the new world order. Anyway, I would suggest those as substantive thoughts for seeking amendments on those bills. Thanks for listening.
Do we have other public commenters?
One moment.
Hello. Hello, can you hear me?
We hear you. You ready to begin?
Yes, I am.
Go ahead.
This is Peter Warfield, Executive Director of Library Users Association, Library Users 2004 at yahoo.com, and P.O. Box 170544, San Francisco, California, 94117-0544. I certainly think that the Sunshine Task Force is going in the right direction to basically express its concerns, as pretty much I cannot disagree with what I've heard so far. Unfortunately, I have not had a chance to read both of these things in full, but I do know that there are many problems that public has when trying to participate with remote meetings using basically the intermediary of the technology. And in particular, I've had a lot of experience for now 2 years of participating in meetings by telephone, which most people who have been commenting on this and weighing in on this haven't seemed to have used or have experience with. And I think there are very particular problems for those participating by telephone. Excuse me, I've mentioned previously that there are a lot of people that do not have computer and internet access. And the city's own study, I think the census as well, will say that the vulnerable populations are the most seriously affected. That's minorities, that's poorer people, older people, those not fluent with English, disabled people. They have a much larger inability to participate. And I think also have certain difficulties with participating that are hard for the folks who are used to dealing with the computer every day and who have support, and they have an IT and a help desk and colleagues who know what's going on. It's a different world when you're sitting in your own home without any of those supports. You've also found in favor of library users associations specifically on a violation that the library commission had, and you had a very specific recommendation, which I believe came through the follow-up committee, that there needed to be a pause to give people a fair chance. So I think there are a whole range of issues that you could weigh in on, and I hope that you do. But certainly there's one right there that you've already pretty much made a determination on. Thanks very much.
And I think that public commenters. Member Wolf, I see your hand up?
Yeah, I just wanted to, I wanted to acknowledge former member Pilpel's suggestions, and I would say not for this particular motion, but I'd be happy to work with you on developing some language that's kind of, folks wouldn't have to work too hard to wordsmith to submit, as a supplemental.
Okay. Any other discussion, or are we ready for a vote on this item? All right, I don't see any hands, so Cheryl, when you're ready, let's go ahead and take a vote.
Member Wolf?
Aye.
Member Wolf, aye. Member Neighbors?
Aye.
Member Neighbors, aye. Member Schmidt?
Aye.
Member Schmidt, aye. Member LaHood? Absent. Member Padmanabhan?
Aye.
Member Padmanabhan, aye. Member Stein? Member Stein?
Sorry, aye.
Member Stein, aye. Member Highland, absent. Member Hill?
Aye.
Member Hill, aye. Chair Yankee?
Aye.
Chair Yankee, aye. Vice Chair Wong, absent. So 1, 2, 3, 4, 5, 7.
Okay. So, Cheryl, if you want to go ahead and call the next item.
Item number 4, public comment. Members of the public may address the Sunshine Ordinance Task Force on matters that are within the task force jurisdiction, but not on today's agenda.
Okay, so this is general public comment for the task force. So if you're interested, please raise your hand, and Victor and Cheryl will coordinate with you. So Victor?
Yes, at this time, if you'd like to make comment on these items, please press *3 to raise your hand. I will unmute the first caller.
David Pilpel again. Hopefully the last time tonight.
David, hang on a second. Stop.
Oh, okay. I could stop or just slow down.
You may begin.
Oh, thank you. Yeah. I just wanted to comment on the last meeting that didn't quite happen, and just to, I'm not sure if Chide to comment that the choice of the task force to not take public comment when you had a roll call vote to adjourn the meeting, I think was a poor choice. I would have commented that that one was able to participate by phone, that was good enough. I would have continued with the meeting last week rather than putting it off until tonight. Whether you chose to do that or not was certainly the appropriate choice for the task force to make, but I think there would have been no harm in taking public comment from me or others on the question of whether or not to continue the meeting. And as I say, having a recorded roll call vote without having public comment on that question of whether to adjourn and whether the meeting was properly noticed and scheduled was unfortunate and a poor choice by the task force. That's all. Thanks.
One moment. Hello, caller. You've been unmuted.
I've been unmuted. Does that mean I should start or what?
Yeah, go ahead.
Thank you. This is Peter Warfield, Executive Director of Library Users Association, Library Users 2004 at yahoo.com, and also P.O. Box 170544, San Francisco, California 94117-0544. The last time you had a scheduled meeting for this, pretty much this agenda, there was a problem and it was canceled. I think it's really important for you to find out, if you don't know what happened and why, and if you do know what happened and why, to lay it out for the public to understand. As a member of the public and as somebody who cares about open government for the purposes of pursuing what we are concerned with, which is helping make libraries better, it's very important to have open government, and it's also very important to understand how this new technology works in practice and in actuality. And I think having a postmortem of some kind would be extremely important and extremely valuable now that you have had a problem with going through with a meeting for whatever reasons, as a way of learning and understanding, and even dealing with the issue that was just on the previous item. If you want to contribute to helping to make meetings more open, certainly having them go off at all, or why they didn't go off, is very important to understand. This isn't necessarily to blame anybody or to hold anybody responsible. The key is what happened. Was it a matter of notice? Did somebody transcribe some numbers wrong? Was there a technical problem? Was there a problem with the understanding or the training or the documentation of the system? All of those are important for the public to understand, and I think for you yourselves to understand, and to help you make a better contribution to the very purposes that you are working on currently. So I hope that you take that up very explicitly, perhaps as a separate agenda item, and hopefully soon. Thanks very much.
That completes the list of callers.
Okay, thank you. And we can go ahead and move on to the next agenda item.
Item number 5, announcements, comments, questions, and future agenda items by members of the Sunshine Ordinance Task Force.
Okay, does anyone have anything for this item? Member Wolf.
Yeah, I just was wondering if the item regarding if a task force member wanted to bring a complaint forward, is that going to be on the Rules Committee agenda? Yeah, okay. Great, thanks. That's all.
Anything else for this item? If not, we can do public comment on that particular question that member Wolf asked.
Are there any members of the public who would like to make public comment at this time? You can raise your hand by hitting *3 or otherwise raising your hand. I see no indication of public commenters at this time.
Okay, great. So we'll go ahead and move to the next item.
Item number 6, adjournment. I have 9:52.
Okay, do we have a motion to adjourn? Anyone?
So moved.
Okay, moved by Member Hill. Any second?
Second.
By Member Wolf. So moved by Member Hill, second by Member Wolf. Everyone in favor, say aye.
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 Aye. Anyone opposed? Okay, unanimous vote. We're adjourned. Thanks, everyone.
Thank you. Bye-bye.
Bye-bye.
Good night.